Okay, we're back. This is Fight Like Sugar. Today we're going to be talking all about the antitrust class action lawsuit that's been filed against the UFC. If anybody's had a chance to look at the quite long complaint, it's 63 pages. There's a lot of material to go over. And, if you've tried to look over some of the other websites out there, they've tried to, tackle some of the main arguments that are there. But to be honest with you, there's definitely been a lack in some of the sort of in-depth analysis. And partially this is the result of the fact that, most of these people, most of these guys, they're just journalists. They don't have a legal background. And it's hard for them. They intentionally, they can only talk about what they know. And recently, in a press call with the attorneys after the announcement and filing of the lawsuit, the press was, sadly, kind of roadblocked a little bit by the attorneys there because they didn't provide them with as much answers as they sure as heck would have liked. But to be honest with you, having been on the other side as an attorney, I can see sort of why that happened. But today we're going to be breaking it down a little bit and hopefully giving you guys a little bit more insight than what's been given out there so far. But I have a first guest here on the little show. And the reason is because sometimes, as a lawyer, you kind of get a little too excited about all the legal, lingo, and you can kind of get a little too nerdy about it. And so that's why we have our first guest here today with us, Alita Silva. Alita, hi, how you doing?
I'm good. How are you?
Good. So this is a little bit of background on Alita and sort of why we've invited her here. So she got in touch with us after listening, reading some of the articles out on the Sports Fan Journal and also taking a look at some of the stuff we've been doing here on YouTube. Alita is a very attractive 26-year-old woman here in Oakland. She's been watching fights probably now, let's say, closely, like about a year or two.
Mm-hmm.
And she's here because she represents a brand new, demographic for the UFC. And a lot about this complaint is understanding the history of the UFC, where it comes from and where it is now. The UFC was founded in 1993. And in 1993, attractive women, any women really, they weren't showing up in Colorado that night when, there was UFC 1. There weren't. And if there were, they weren't what you would find or what Alita is, and that is a casual sort of female fan, who can walk into a fight, watch it, enjoy it. And I've been witness to this, be quite animated, I think, when submissions come on. I remember
Definitely.
her reacting quite intensely to Frank Mir's total destruction of using his Kimura against, oh my God, I'm totally blanking on his name right now. But that doesn't really matter. I just remember screaming and watching the shoulder pop out the socket.
It was very exciting.
Yeah. And so that's why she represents this new demographic, and she's a layperson. She's not an attorney. She's a teacher. And so as I'm sort of breaking down down the complaint and going over some of the nitty gritty, she's going to force me to stop, be quiet, ask some questions a little bit. And so anytime, I might lose, the people out there listening to this, hopefully she's going to check me and bring me back down to reality. So we're answering questions that, you guys that you want to know about, and that so you can really understand what's at stake in the litigation. So thank you for coming along and helping us out with this.
Of course, I'll try my best.
Cool. All right. So let's start this thing off. So the complaint was filed December 16th. It's only 2 weeks old basically now. But let's start out with the players. I think everybody knows. So the UFC is the person who's getting sued. Sort of. It's not really the UFC. It's their parent corporation called Zuffa. It's not Dana White. It's not the Fertitta brothers who own most of the shares in Zuffa, right? It's just Zuffa themselves. On the other side, there's three there's three fighters that have are what's called the named plaintiffs: Cung, Nathan Quarry, Jon Fitch. Fitch, excuse me. Everybody knows about them. That's fine. Those are the regular players. Not a big deal. I think what a lot of people haven't really noticed yet or haven't really talked about is who are the lawyers. And I think that matters quite a bit. And it does, especially when eventually when the UFC hires its lawyers to defend it. You can bet they're going to hire some really expensive, really high priced, very respectable, intimidating lawyers, to represent them. And when you're on their side, by way of background, I've been an attorney for several years and have represented some very big name companies and been involved in $1 billion litigation. And when you're on And when you're there and you work for, one of the oldest firms in California, like I used to before switching over to a different firm, you know that, who you're up against is like the first thing that we look at. Like, who are these guys? What do we know about them? What are they known for? Are these guys known to settle? How much of hardball do they play? And all of this figures into the negotiation, right? And the number one guy who's representing the class, we'll get into that. In other words, the fighters who are bringing this lawsuit, is a guy by the name of Joseph Saveri. This guy has a very well-known, respectable law firm out here in San Francisco, and he's got all the bells and whistles. He's on U.S. News lawyer rankings. He's a part of the Super Lawyers magazine rankings. He's on Who's Who. He's gotten legal awards from Who's Who as well. And I think the most important sort of recent accolade that this guy has gotten from, a news outlet called Law 360, something that a bunch of lawyers, we all subscribe to something that Law 360 does. And this guy was just voted by them as a quote unquote titan of the plaintiff's bar.
Wow.
Yeah, this guy is, he's already brought lawsuits against guys like Apple, Google, Pixar. So while, in the MMA world, everybody is like, oh my God, the giant is getting sued. Overall, I mean, Zuffa is tiny, by comparison to things like Apple and Google, right? So this guy has nothing that Zuffa and their lawyers do are really going to intimidate them, are going to be new, because man, you can sure as hell bet that Apple's lawyers and Google's lawyers were ready to put up a fight and did put up a fight. And so this guy is seasoned, he's ready for that. So for anybody out there who has the hope or the potential or thinking like, oh man, Zuffa's just going to run over these guys, like they're not going to know what hit them, you can just take that out. You can just forget about that. Like, these guys are here to fight for real. And so that's the first thing I just want to lay that out there. So we understand the players. Joseph Saveri, his law firm representing the plaintiffs, and he is going to be one serious contender and not going to shy away from a fight. So then I think the other part that we want to start getting a little bit of background before we get into the nitty gritty of stuff, right, is the process. And a lot of, I think most people don't really understand sort of how litigation works or how a lawsuit works, right?
Mm-hmm.
You've heard about, hey, somebody gets sued and then people are like, oh, then you go to trial and then you either win or you lose and then you get paid. Well, I mean, kind of. It's a really long timeline. There's a lot of steps in between. So quickly to run down what's going on, right? Complaint was filed December 16th. By statute, there is a required answer, which what it's called. In other words, it's where Zuffa has the opportunity to say to every single paragraph of the complaint, this is true, this is not true, or the more popular answer, I don't have enough information to admit or deny that this thing happened. And it's their official response to all of the bad things that the plaintiffs have basically said that they've done. And that's how they respond, right? But as a sort of legal strategy or approach, you don't want to get there. Because once you get there, you're moving straight into discovery and things start getting expensive, and we'll go over what discovery is in a second. But so before you get to the answer, you have the opportunity to file what's called a motion to dismiss. The motion to dismiss, in short, is your argument saying that the complaint that was filed is deficient in these different ways. It's so deficient that it's not legally understandable, or it's legally does not create an actual claim. And this is where a lot of money is going to get spent, and you can bet your bottom dollar that Zuffa already has their attorneys, and they are furiously working on getting their motion to dismiss ready, as well as most likely filing for some extensions and some other things. But that's really the next milestone, is the motion to dismiss. From there, and this is where things start to get a little fuzzy, because even that process right there can go for years.
Oh, wow.
Yeah, I've been involved in a litigation where we had our initial complaint, and the motion to dismiss and all of that was verging on about a year and year and 7 months. and we hadn't even gotten a final response from the judge on all of our motions. And part of that is because the other little nit here is that the UFC, or excuse me, that the plaintiffs at any time, if they feel like it, they can also amend their complaint. So right now it's 63 pages. They could make it, they could add more, they could take out stuff, and each time it amends, it can reset the clock, and depending on what happens between the lawyers, it just can expand that whole process.
So you're saying that there isn't a hard deadline for the complaint to be finalized?
Exactly. I mean, practically speaking, you can amend a complaint. You can amend a complaint all the way up through. I mean, almost around the eve before trial. But again, this is all about the back and forth between some of the lawyers and how they're going to work out. But it's in that process of amending it and then responding or setting a new motion to dismiss, and then how well those attorneys work with the judge to sort of see at what point you're able to sort of move into the next phase, which is discovery, which is the long period. And discovery, I think, for most people is most recognizable by depositions, right?
Mm-hmm.
Everybody, I think, if you've been in the fight world, you might have caught depositions of like Sugar Shane Mosley for the Balco scandal, the steroid stuff, or probably everybody, in the last few years, the most recognizable sports deposition out there is Lance Armstrong when he got caught, or old depositions when they were accusing him of doping, and videos have come out for that stuff. And that's all those depositions, as well as other much more boring things like requests for production, and that's when you get to exchange papers, and all that stuff drags on and can drag on for years.
And that potentially would drag on only if the motion to dismiss fails.
Exactly, right?
Okay.
So, well, let me amend that a little bit. It can, for example, happen, some discovery can happen even before the motion to dismiss is finalized.
Okay.
It just depends. Usually, the name of the game on the defendant side is delay, right? They want this thing to drag on as long as humanly possible.
And why is that?
It's for a lot of reasons. Because again, when you're the defendant and you're a huge company like Zuffa, right? You've got the dollar signs. And a lot of times, big stake litigation like this is a war of attrition. I can pay my lawyers to defend me a lot longer than you can, pay your lawyers to advocate for you. Okay. And so delaying is a big tactic. There's lots of deadlines that go on, and nobody's filing before the deadline. Everybody's like filing 2 minutes before the deadline is there, because the defendants are, they want to take longer because, yeah, they want to delay the process. Plaintiffs, on the other hand, if they could get to trial faster to make this thing to define whether or not they've got their money, that's what they want to do, because their resolution, especially in this case, right, you can bet that the Severi law firm is taking this thing on contingency. Like they're going to get paid when the plaintiffs get paid. Like they're just going to take a piece of it.
Okay. So that would kind of get them more inspired to get to that point then in the process. Exactly,
right? You want to get paid today more than you want to get paid a year from now, right?
Yeah.
So that's kind of that's what the process is going to be. That's the overall strategy. Defense equals delay. Plaintiffs equal push forward. Kind of a simple, little way of understanding that. I think sort of the next background element that we got to understand about the litigation is, and everybody, again, you've heard the names, Cung, Fitch, Quarry, but they're the names on the complaint right now, but it's not about them as individuals, right? Like this isn't a lawsuit where I sue Alita. That's not what's happening, right? This is where a representative, Fitch, Cung, Quarry, on behalf of these quote unquote classes that they represent, are suing this huge organization. And the classes are incredibly important from a legal standpoint. So let's talk. There are two classes. There's number one is a bout class. And the bout class has basically been defined as all fighters who've competed in one or more UFC bouts or fights in the US during the quote unquote class period, which is, we'll get to that part. The other one is the identity class. The identity class are all UFC fighters who have had their identity, and this means likeness rights, personality rights, the right to use your image in print, your name, those particular rights that have been taken away by the UFC and that the UFC maintains in perpetuity. In other words, forever, and to use them however they want, whenever they want, right? Bout class, the guys who throw bows and fighting. Identity class, guys who have had their personal identity rights taken away from them. Those are the two classes. And part of the process, that I didn't mention particularly about the whole in the process thing that I mentioned the motion to dismiss. There's also, should have mentioned it there, something really big called class certification. Mm-hmm. And this gets really technical. The short of it basically is that class certification is where the lawyers are going, there's certain requirements for a class, in other words, to bring a class action, and there's certain legal requirements, and class certification is where the judge basically says, yep, you've met all the qualifications for a class action, and now you can proceed with the class action, and then there's a motion to dismiss and whatever. The least expensive way for Zuffa to make this case go away is to win at the class certification stage. They've got to find a way to say, there's a couple of different arguments, some of them being this class is not representative, like the injuries suffered here are not representative. It isn't so cumbersome that they can actually bring these cases individually. You can, there's no, what else? There's 5 different, categories that you can bring up, but this is where really the UFC wants to save its money, and that's what they're going to try to do. Whether or not they're going to be successful about it, that's a whole nother idea. I have no idea. That's going to be that's going to be a fight. I mean, this is where class action lawyers, really get make their money. But it's going to be in one of those different areas. The easiest, class certification. Whether there's too many people, that one's going to be pretty easy to satisfy usually. Then are there common questions of law or fact amongst all of these people? This can be super hyper technical, but do all of the individuals, like all the UFC fighters, do they actually face the same legal injuries? And are the facts roughly the same amongst them? Maybe, maybe not. By the way, throughout this entire podcast, we are making here at Fight Like Sugar absolutely no commentary on whether or not it is a lawful, unlawful acts have occurred. We're not siding with either side. We're just trying to break down the facts as they have been presented in publicly available documents. Just want to get that out of the way. One of the other ways you can attack it is by saying that the defenses that are available to these groups are basically defenses or that are available usually to the class or to these individuals, and they've got to be similar, right? Like everybody can't be sort of the faults that they've suffered, they can't be repaired in so many different ways. It's got to be like, all right, well, all of these people can basically, if we do this one action, all of them can be remedied the same way.
Which is why they do it together. Exactly,
right? Because the idea is that a class action helps the courts because they don't, instead of, having to try 1,000 cases, where, we all know that federal government has a tough time. Their budget is pretty limited. The courts are already jammed. And instead of, it serves the interest of the people, essentially, to have one class action as opposed to 1,000 cases.
So basically you're saying that if Zuffa finds that the class action has individuals who do not have this commonality, then they can break apart the class action suit.
Yeah, well, try to. Exactly. So they're definitely gonna argue. Yes, they're definitely gonna argue that there's no commonality here, and all it's the judge who's gonna decide. But that's right. There's no doubt, 100% in my mind, they're gonna have a nice fat part of their brief attacking commonality of these guys, and then the last one, which is kind of a sneaky one that some people don't worry about enough, is whether or not the class representatives are going to be sort of fairly and adequately protect the interests of the class. This can be a big deal in different types of class litigation. This is more so sometimes, or in the past, has been a bigger issue in securities cases. I don't really foresee that being a huge one here, but it is something that they've got to satisfy. But anyways, again, the classes, the two that we're fighting for rights are bout class, people who fought one fight in the UFC during the class period in the US, and identity class, fighters that have had their identities taken away. So now let's start getting into a little bit more nitty gritty stuff, like what is a class period and why does it matter? Well, the class period, basically, it says in this complaint, all of this bad stuff happened, and after or in between these two dates, that's when all the bad stuff really matters. And for any damages that have occurred in these dates, that's when we get money back for. And the complaint has set that class date at December 16th, 2010. Mm-hmm. From then up until the supposed monopolistic scheme has been erased, which they basically say it's still going on. So up until the present. Well, December 16, 2010. And they don't, this is the funny part, right? This is one of the first things that I noticed in the complaint going through it. They don't actually tell you why they pick that date.
That was going to actually be my question to you. But so we don't know why.
Well, we don't have, you're right. We don't have their official response why. And this is part of the legal strategy part, right? It's early. Their requirements for a complaint don't require them to specifically identify why this date. Not that you don't have to do that right now, right? And there are reasons why you wouldn't. One of them, to be honest with you, is because, they want some wiggle room and they want time for discovery to happen, right? And so they want to have time to ask the UFC to give them their documents so that they can start reading through all of these documents and all of this stuff on the inside to help them both support and, give support to this date, but also maybe find a new one and a better one, but they have to put something down. So then why did they pick this date, right? Mm-hmm. Why is it there? Well, the date, obviously we know that it has to be an important date to the plaintiffs because they couldn't have just picked any date out of the sky, right? So they've got some reason why they've picked it. They didn't decide to share that with the public yet. But I've got, if we look through the timeline of MMA, December 16th, or the month of December in 2010, is actually kind of a big month. Hardcore fight fans might remember it the best for the debut of Anthony Pettis' infamous Showtime kick. It's when he ran up against the cage wall and just propelled his body off of it, ninja kicked Benson Smooth Henderson in the face, knocking him down. Mm-hmm. Maybe the single greatest kick in MMA history.
That sounds impressive.
It's amazing. It's just, it's something you can watch on highlight reel again and again and again, and you never forget it. And that happened December 16th, 2010. But that's probably not why, right? Obviously, they're not going to pick it for that date. So, but what else happened that day? Well, that show, or that kick, was on the WEC's, the World Extreme Cage Fighting's, last promotional event that they had. After that, the WEC caved in on itself and was eventually acquired by the UFC and run as a separate, and then completely caved in on itself. Interesting. And this comes into play a little bit later. You might be like, wow, what does the UFC's last event have to do with the UFC and Zuffa? And it ties in, and we'll get into that a little bit. But for right now, remember, December 16th has to do. I mean, that's the one big event that I particularly have noted in MMA history that happened on that date, and it ties in with some of the other themes in the complaint. Maybe totally, the plaintiffs have something else. Again, I don't know what they're thinking, but this is a particular event. It matches up with some themes. We'll keep that in mind as we keep going over some stuff. The next thing is, so there's two words that get used a lot in this complaint.
What are those?
Monopoly is one of them. Mm-hmm. Everybody, I think, has heard the word Monopoly, right? We've all played Monopoly at least.
I think so.
Right. So, but what is a monopoly technically? Well, essentially, it's a situation in the market where there's a lot of buyers or a lot of consumers, and there's only one person to buy it from. Kind of simple, right? It's as if imagine there was only one supermarket in the whole of your city. Well, they'd have a monopoly on it, right? That's the only place where you can get it. In the UFC context, what they've alleged is that the UFC is essentially the only company where MMA fans can get or watch elite MMA fighters compete. Then there's another word that you've got to look up. It's kind of hard to pronounce, honestly, and you got to look it up on the Old English Dictionary to make sure you got it right. And it's called I'm gonna butcher it right now. Monopsony, right? And a monopsony is a much less popular word. People are like, "What the hell?"
Yeah, I think that's the first time I've heard it.
Yeah, a monopsony. And what is this? This is a totally different situation. Almost the exact opposite of what a monopoly is. It's where there is a lot of producers or a lot of seller of goods, but only one buyer.
Interesting.
And you're like, well, what is it? What does that look like? Well, so this usually happens in labor situations, right? Where there is hundreds and hundreds and hundreds of people who want to work, and they want to work and they're willing to work. But imagine that there was only one company that could hire them. And what the plaintiffs have alleged is that the UFC has created through various means a monopsony. And that means for them that there are hundreds and hundreds of MMA fighters in the world who want to sell their fighting skills and their ability, but that the UFC has created a market where really, realistically, the elite can only essentially get bought by the UFC.
That's interesting.
Yeah, it's a big statement, right? And you can imagine if the UFC has been able to create an environment like that, where they're both the only buyer of the goods and then the only seller of the goods.
Yeah.
That's
sounds very cyclical.
Exactly, right? One definitely feeds into the other. And it makes them one hell of a strong business. Well, obviously. One that would, if it were true, would run afoul of the antitrust laws. But those are the two words that are throughout the entire complaint that you're going to see. And so hopefully these definitions are going to help understand a little bit, or help you understand a little bit of what's going on as we delve even deeper into the complaint. And I think that the other thing that people are really interested in, as in all things in life, money.
Of course.
Right? How much is this going to cost the UFC? How much is it going to change fighter pay and all of that stuff? And it was a very popular topic of conversation on the press call with on the press call with the lawyers of the plaintiffs. And what do you think that they told the press when they asked about that?
I'm guessing maybe they didn't say anything about money.
Yeah, that's right. They didn't say. They were like, "Oh, we don't want to get that specific, and we'll figure it out later." And
it's not even in the complaint.
No, okay. Not the complaint. And that's not being in the complaint is totally normal. There's nothing abnormal about that from a legal standpoint. But I've had some great mentors, and a lot of them, they like these lawyers have cautioned, you gotta be careful, obviously, what you say to the press and all that. But at the same time, if you're gonna call a press conference to announce your lawsuit to the world, because everybody's interested in it, you gotta give them something. You can't. I mean, otherwise, just like a big tease, right? You gotta give them a lot, like of a bone. And that would have been a great one, but they didn't. They kind of punted on it. They didn't want to talk about it too much. We're gonna get into that a little bit later, because I think you need to understand what are the actions that have been alleged that the UFC has done to understand. That'll help you understand how much money is at stake here. But so that's definitely something we're going to get into, and we've got some guesses as to figure out how much money are we really talking about. So this whole case is about this alleged scheme. So in a scheme, it's a series of events, a series of steps that have been taken by the UFC. There's no one thing that the UFC has done that has made it violate the antitrust laws, according to the plaintiffs, right? They're saying they're doing a whole list of stuff. And there's a lot out there. And so we're going to break each one of these down. And so one of the things is quite simply like they've locked up the best talent, right? And they've done it by one, acquisitions. They bought the WEC. That's how they got Dominic Cruz. That's how they got Showtime Pettis. That's how they got Ben Henderson. Then they bought the World Fighting Alliance. And then they also bought, everybody knows, Strike Force. And they bought a bunch of other places. So anytime you knew of a big name fighter from one of these promotions, they got bought up.
Mm-hmm.
So that the UFC at one point they were like, whoa, every big name I know they're all in the same place.
Yeah.
Right. And so that was one scheme or one thing that they did to lock up. But then there's other stuff. So in some of the, these UFC contracts, what they did, according to the complaint, is they instituted non-compete clauses where, Alita, we're going to give you, we're going to guarantee you 2 fights and that we're going to offer you 2 fights this year. But for the, in exchange, you are going to get paid this much and you cannot compete whether or not you're actually fighting for us for any rival promotion.
That's limiting.
That's limiting.
Yeah.
Right? Exactly. So even when you're not working for us, like actively, because you're not actually in the cage, you're not fighting, can't go work for somebody else.
But is the money incentive enough to do that, to just work?
They're right. So that's a big question. And the plaintiffs would probably say, well, no, but the situation is that they can't sell their services elsewhere, right? Like once you get to a certain level, they've got to go to the UFC, and I'll give you a concrete example of that a little bit later, but they're going to say no, right? And that once they're locked up in these promotional contracts, it makes it really hard for them to go anywhere else. Mm-hmm. I think a surprising one that I learned about while reading the complaint is the championship clause. So you sign your contract originally, sign it for, let's say it's 3 years, whatever it is. And in those 3 years, let's say at 2 years and 11 months, you win the UFC title belt, right? You're now on top of the world. And maybe you want to continue fighting for the UFC, or maybe now that you've got this huge press, right? You're like, oh man, I'm on top of the world. I'm the number one dog at the biggest MMA promotional company in the world. I wonder what one of these rival promotions would offer me, because they're small and they want to grow. Mm-hmm. Maybe they're going to offer me way more than what the UFC is offering, right?
Yeah.
Well, the UFC has something called the championship clause, essentially, or what the plaintiffs are calling that. And it basically says champions of the UFC automatically have their contracts extended. So even if your contract was about to go up, or even if it does go up, it lapses. Mm-hmm. Guess what? It extends for the duration of your championship.
Even if you don't re-sign the contract.
Yeah.
So by me signing the contract the very first time, I'm automatically saying that if I become a champion, I'm also signing to and agreeing to the extension of my contract if I'm a champion.
Until you're not a champion, yeah.
Until I'm not a champion. Interesting.
And obviously what comes along with that is the non-compete. So
that means
you're not going to be able to then take your flashy new UFC championship belt and run with it somewhere else and try to compete at another promotion company, because you're still a fighter for the UFC.
Why would you want to take your UFC championship belt to another company, a different company that's not UFC?
Okay, and by that I mean, in other words, the status, right? The status, okay. The physical belt. That's not the thing that matters. Mm-hmm. Because let's give you an example. Strike Force. They were probably at one time the largest, most reputable MMA organization other than the UFC. Mm-hmm. And they were in competition, especially up here in Northern California. Imagine if Cain Velasquez, right? Huge. I mean, this guy, huge on talent, huge on marketing potential, Mexican-American, heavyweight champion, dynamic fighter, maybe not the greatest interview in the world, but dynamic fighter. He wins the belt against Brock Lesnar, mm-hmm. has defended it. He lost it, then won it back, and has put on amazing performances against Junior Dos Santos, but he's been injured for a while. Mm-hmm. All right. Let's say this had all happened back when Strikeforce was still around, or if they were still around now. Well, they're like, well, man, they're holding, and they did hold a heavyweight championship tournament, right? And what if they could get Cain to sign with them to come over.
Mm-hmm.
Like instantly, all of the people who've been watching Kane grow in the UFC, all those people and know how exciting he is to watch and who never misses fights, they're immediately going to turn their heads and go to Strikeforce.
Yeah.
Or go to whoever, right? And that's what this other promotional company could be buying.
I see.
So if I was a new promotional company and let's say I was a billionaire, and there have been billionaires who have tried to get into the UFC market.
Mm-hmm.
Mark Cuban is one of them, but his company failed. And then he ended up buying parts of, or has a stock interest in Zuffa now. But, let's say, money isn't much to him. So let's say, he knows Cain Velasquez is up for sale for a little bit. And he's like, you know what? I know the UFC doesn't pay you that well because they don't. And they're like, yeah, your next fight, we'll pay you $8 million. He would, $8 million, he would run.
For sure.
But he can't because of the championship clause.
Well, do you happen to know what's the penalty for breaking that contract?
Yeah, well, the penalty, there's no, this is where those lawyers come in, right? So if he tried to go somewhere else, then Zuffa's lawyers would file an injunction immediately stopping it and preventing it from happening. So he would never get there.
Oh, interesting.
So how else have they locked up the talent? Well, they've got this thing called a right of first offer. And so let's say that after a UFC contract ends, you were the champion and you were forced to stay for a little bit longer. And then you fought one more time and you lost. And so then your contract is officially over because you're no longer a champion. You decide not to resign. And then you get offered a bout with, again, a rival promotion. The UFC, through the right to first offer, allegedly, apparently also gets to match whatever offer is given to you. So you're almost free, right? Mm-hmm. Your contract is up and you just got an offer from someone else. You have to give the UFC the option of matching it. And if they match it, you got to take it.
Have to? Even if it's the end of your contract?
Yeah.
Does that mean then that your contract it's not really the end?
Almost, right? Exactly. That's the start of, that's the flavor that it starts to take on.
I get it. So basically the UFC is saying that technically we reserve the rights to have you forever because whenever your contract is over, if we really still want you, all we have to do is match whatever pay you're going to get from someone else. Which if they want you bad enough, they will match it.
That's right.
Okay.
That's the flavor. That's the picture that the plaintiffs are starting to paint. Slowly but surely. And they do it. They're very meticulous about painting it, right? Obviously, the UFC is going to have their chance to rebut these things by presenting the contracts themselves because as of right now, these are all allegations. In other words, these are not facts. They've been alleged things that one party says are true, that another party has the complete right to not only say that, well, there's nothing wrong with doing that if they exist, but they also be like, this doesn't exist. This is completely fictitious. You've made it up. So we don't know if it's true, but this is the picture that they're painting.
So I'm assuming from hearing all of this that the fighters have no union.
That's right. There's no fighter union.
That's my teacher side coming out here. I'm shocked. It's terrible.
Right. For guys who take such a beating and is such a physically demanding sport, you kind of wish that they had a union to protect, but they don't have one. Boxers don't have one. Fighting sports have never been good at developing that. And then we could have a whole podcast on why that is. But we don't have the time for that, but that's right. So then let's do, how else do they lock up talent? Well, the other way is a little bit less, or I should say it's a little more theoretical, in other words, or it's not as plain to see. They lock up talent, even though not the actual physical person, by controlling their identity rights. There is a clause inside of the complaint that says the UFC controls your personality and identity rights for all commercial purposes and holds those rights forever, even after death. That's huge.
That is.
Right? And all sports fans who, have been paying attention to the news in the last few years know that this kind of sounds a lot like a lawsuit that was filed against the NCAA, because the NCAA does something very, very similar and have used their rights to control the identity of any player in the NCAA to make very lucrative partnerships with EA Sports and create games that everyone in the people in the United States play to the tunes of hundreds of millions of dollars. Well, that's what the UFC does, right? They control those rights, and so they create video games with them. And when people in the past, as has been alleged, have tried to negotiate, like, well, wait, like, if I'm going to be in this, well, I want a little bit of kickback. I'm like, no, you're doing it for free. And then obviously, when they have those models of those bodies and like, they're like, oh, you look so much like you look like the real thing. Well, how do they do that? Well, the fighters got to come in and they got to get painted and they got to get these little machines all hooked up to their bodies. They do that for free.
So they're not getting a cut out of any profits made.
Well, I can't say whether or not anyone does, because I obviously haven't seen the contracts. But what I can say, if the allegations are true, then what this is saying is that they don't have to. And they probably are not. And there are examples of some that are named in the complaint where fighters who have asked for points, in other words, points on the package, they want a little bit of money, right? Have been fired for even asking.
Really? So that's, ladies and gents, that's a nice way to get out of the contract. Just ask for more money.
But they're still going to use your likeness.
Still after getting fired.
Yeah, it doesn't really matter, right? They control it. They control it forever.
So you get fired and they still get to make money off of you after letting you go. That's great.
Exactly.
That's awesome.
Yeah, exactly. So that obviously, this is for someone, in this day and age of sports, when we have icons that transcend their sport quickly by making huge amounts of money outside of their sport. LeBron James makes an ungodly amount of money outside of playing basketball. Tiger Woods makes an ungodly amount of money selling his face, to Buick and to Tag watches and to Subaru or whoever it was, or, whoever he had. So controlling, your identity, your likeness, your figure, all that stuff means a lot of money. And the UFC owns their personalities and owns that right forever.
So does that mean that if I'm a UFC fighter, my contract is over, I work for another company and UFC doesn't actually want me anymore, they can still use my likeness even after I'm not working for them anymore?
Yeah.
So does that also mean that whatever company I'm working for at that time, in addition to UFC, is also using my likeness, or does the UFC has exclusive rights?
That is a great question. And that, to be honest with you, is going to be something where that may present some issues for the bout class, or the identity class, because the difference between those two things is a big one. And, your ability to, I'm sure that the answer to that might be, it varies between people, whether some of them are exclusive and some of them not. Like probably for some of the superstars, they weren't able to get that, but with some of the little guys, maybe they have. I don't know. And this is why it goes back to, these are allegations, right? So maybe each contract is different, and that would be that would hurt the identity class in this class certification phase quite a bit. But my guess is that most of them are not exclusive. Because there are examples of fighters that have moved to other promotions and they get promoted and they get to use your likeness rights and other stuff. So that would be my guess, but I don't know. So how else have they locked them up? Well, we already know UFC never co-promotes. There's never a UFC and Strikeforce co-promotion fight. That's never happened. It didn't happen. You're like, well, that's not a big deal. Like, well, it's only, and nobody's like, well, no, that never happens. We're like, well, it never happens because the UFC doesn't do it. But there are examples. Strikeforce, when it existed, was willing to co-promote. And if you look over at boxing, that's actually I don't want to say it's the standard, but it has historically happened regularly. And let me give an example of that would be during one of the greatest fights of the 1980s. Don King, Don King managed Roberto Manos de Piedra Duran, and he co-promoted a fight against a top-ranked fighter, top rank run by CEO Bob Arum, Sugar Ray Leonard. Sugar Ray Leonard versus Roberto Duran is a prime example of the best fight that could possibly be made, and it only was made because of a co-promotion. That never has happened in the UFC. And that leads to, again, from the plaintiff's perspective, a further lockdown on the opportunities of the fighters and the MMA and the UFC's control over the MMA market. We got to get a couple of other, and there's plenty more. We're gonna go through all of them because I think all this was super interesting. This one was a little bit surprising to find out, and it's that the UFC apparently, or allegedly, has or creates exclusive contracts with particular venues, such that it prevents those venues from working with any other MMA promotions.
Oh, really?
So in Northern California these days, if the way it would work, right, is that let's say they have a show at the Oakland Coliseum. They might use a contract or an exclusivity clause in order to prevent them from ever holding a fight for Bellator. And what the complaint further alleges, and this was shocking, and I can't wait to see more facts about this. According to the complaint, they say that they've used this on every major venue in Vegas on the Strip, so that no other venue can promote on the Strip. I was shocked.
That sounds like a monopoly to me.
That's shocking to me. Mainly because you think of these, all of those studios. All of those casinos. They make billions of dollars.
Yes.
And according to the plaintiffs, that they were willing to sign on to that. Maybe it's because there's no other fish in the sea, so they're not worried about it. Or maybe they're afraid of losing out to one of the other competing studios because the fight business is a competitive one. I don't know, but if that's true, that's just crazy. I was just totally shocked. I did not. It was shocking that they would have such a tight grip on MMA or in Vegas that they could do that. But that's exclusive contracts with venues. Really surprising. But to go back to the fighters, one of the most shocking things that come out of the complaint is the amount of control that the UFC has over sponsorship endorsement deals. Everybody knows, get into sports, some of the biggest paydays you're going to get are with Nike, with Gatorade, and those guys, right? Like, that's where you get those big promotional dollars. You got to get those sponsorships, get that swoosh on your hat, on your shirt. Not only are you getting a bunch of free clothes, but you're going to get a fat checks from them. And it also helps build your individual brand, right? Aside from the UFC. Well, allegedly, the UFC has a sponsorship fee, or a tax, if you will. In order to sponsor one of the UFC fighters, well, they got to pay something to the UFC.
I see.
And we're not talking about piddly money here. We're talking about anywhere, allegedly, $50,000 to $250,000. That's
insane.
Right? And we think about that. You have to pay us so you can sponsor this guy. I don't know.
Do you know if that's usually tends to be a flat fee or a percentage of what the fighters are paid already?
Wasn't mentioned in the complaint. So we don't know. But that's sort of surprising. But there's another element of that, right? It's not just the fee, but the UFC has control over who the sponsor is, right? So that, and some people might be saying, well, the NFL does some of that too, and they can control what gets used inside of the cage or whatever, right? Well, it apparently seems to be different if you're going to follow what the complaint is here, because it says they will basically the UFC will block out certain sponsors that they don't like because they work with other people. Right. And so I've worked my butt off to be an awesome fighter, and I win a championship belt at the UFC, and then Tap Out Apparel, right? Big in the MMA world. They come to me and they're like, hey, we want to sponsor you, whatever. But the UFC's like, you know what? No, because you work with these other people, you can't sponsor this guy. So I'm gonna as a fighter gonna lose out on a couple $1 million because my promoter doesn't like the sponsor. Because not because they're morally opposed to them, because they work with somebody else. And again, it's the focus is on the competition, right? They're getting tighter and tighter control on the fighter, but at the same time pushing out competitors because, if they're working with other people, a top brand like that, then it's going to help, that other MMA promotional company to grow as well. And they don't want that. So they're like, well, we're the biggest guy in town and we're going to keep that other guy small by not letting you work with them.
Wow.
And one of the great examples that they had in the complaint in there is that, everybody knows that for the longest time, the UFC was in negotiations, bitterly fought negotiations with Fedor Emelianenko, one of the greatest heavyweight fighters of all time, one of the most feared men of the planet. And he refused to sign with the UFC. And according to the complaint, when that was occurring, they found out that Tap Out was going to offer Fedor a 7-figure payday endorsement deal. And when Fedor didn't sign, they told Tap Out that if they signed Fedor, then Tap Out was no longer welcome inside the UFC.
Wow.
And so he lost a 7-figure payday.
That's insane.
Wow. That's really intense. It's really, really intense. And there are other situations where that is. Another one was where Quinton Rampage Jackson apparently was involved in getting a Reebok deal, but because the UFC has to get involved in those sort of negotiations because they're going to get their fee, obviously, from him for that part, and also in determining whether they're going to allow that into the cage. Eventually, what ended up happening, according to the complaint, is that, Rampage didn't get his deal, but instead that's what led to the more recent Reebok deal between the UFC and Reebok now, that they're the official sponsor for all the UFC.
Wow. I wonder if it was worth it.
Yeah, exactly. That's a whole nother thing we can talk about later as well. That's and how that's going to affect the fighters is who knows, but.
And that's something that's definitely in the contract, that UFC decides who can sponsor you and who can't.
Yeah, that's what they're saying. That's what the plaintiffs are alleging.
Wow.
That's what the plaintiffs are alleging.
But I'm guessing that if UFC turns down a sponsorship on your behalf, they won't make up the money that you are losing.
I highly doubt that. Yeah, I highly doubt that.
That's a rotten deal.
Yeah, and so let's see. I think the last one we're going to really talk about is the promotions clause, which is an interesting one. It says that UFC fighters basically have to attend press conferences, interviews, all that stuff, that fans really want to see, and they're required to do that. And to be honest, kind of standard, at least in a lot of the other big four sports. Like, everybody's got to attend these things, and they've got to show these things because they got to market the sports. Interesting though is that there's no equivalent, there's no reciprocal clause. In other words, the UFC, there's nothing in there that basically says Dana White has to promote the fighters. In other words, that he has to build them up.
Yeah.
And quite in fact, if anybody who's watched more than one interview of Dana White knows that he quickly shits all over fighters that he doesn't like. He's not shy. I mean, it's actually one of the great appeals for the man is that he doesn't mince words, but he will cut down fighters when he disagrees with them. He'll cut down trainers, cut down all sorts of people.
Yeah.
So there's no reciprocity there, right? It's fighter gives, promoter takes. Promoter doesn't have to give that back. They don't have to build them up, but obviously if they don't show up to the press conferences, you can best believe that the UFC will cut you either out of a fight, like they did Nate Diaz once, or cut you from the whole promotion.
Wow.
And then the last one is, there are no competitors, and the few this is what they're saying, is that the few MMA promotional outfits out there, like Titan FC, Legacy FC, and others, they aren't actual competitors. They're more like minor leagues. And why? And the way that the plaintiffs have colored this picture, painted this picture, is that those other MMA promotions have what's called Zuffa out clauses. In other words, if you're a fighter at Titan FC and you get good, and Zuffa UFC comes around knocking and is like, hey, we want to offer you a contract. Boom. There's a clause in that Titan FC contract that says you're immediately let out of yours so you can go into the UFC, into the big leagues. So they're not really competing, right? Because obviously if you're really good, that other promotion should want to keep you.
Yeah.
Right? Because then as you get more popular, you're competing with the other fighters at the UFC and for ratings and for attention and for viewers. All of that's nullified by the Zuffa out clause because, boom, immediately you go off to the UFC.
Okay.
So they're minor leagues. And so they've restricted competition by working with these other promotions to create this feeder system.
Streamline it.
Exactly. Can't be competition if you're giving away all your talent to somebody else, right?
Yeah, especially if you're in agreement.
Exactly.
That makes sense.
So these are all of the different tools, if you will, that the plaintiffs say that the UFC has used in order to A, create the monopoly. In other words, become the only place that can buy up elite talent, and B, become a monopsony other way around. Create a monopoly where they're the only ones, putting on the super huge fights of elite MMA fighters to the fans, and a monopsony where they're the only ones who really can buy the elite talent and control all of the different service providers out there. So knowing all of this stuff, let's talk about money, right? What do we know about the UFC and how it's grown? 1993, UFC's founded. The Fertitta brothers and Dana White, they buy the UFC for $2 million, right? Between October 2012 and September 2013, plaintiffs allege that the UFC has basically brought in about $500 million in revenue. And the split is interesting. They say that there has been $256 million made just in live promotional events from the gates, in other words, people attending and all that stuff. And then almost the exact same number, $227 million, have come from what's called ancillary revenue streams, merchandising, sponsorships, licensing fees, advertising fees, video games, etc., stuff like that. So half of the business comes, so I think of it this way. Half of the business money comes from actual punches, right? Half of the money comes from the image of the UFC, if you will, right? The image of the punches and stuff like that, which is important to note, not necessarily for this case, or not necessarily for the thing at hand, but it kind of gives you a new perspective as to why it's really important that guys like Nick Diaz or whatever, they play the game, that they're presentable, that they attract fans, that you be able to control that likeness rights, because half of their money's coming from that. Right? And that's why, by the way, legal strategy point, that's why they've broken up the damages in this way. You see that? Bout class, the people who have fought in one fight at the UFC, what number matters to them? The $256 million, right? And then the $227 million, that number corresponds with the identity class. Why? Because the way it's defined, all that money is coming largely from forms of revenue that would come from those identity rights that have been denied or taken from the people. So that's something for journalists to point out there. That's, again, the plaintiffs they have not said that specifically. I'm trying to break that down for you, give you an idea, what are the numbers, what are the boundaries, right? That's the breakdown between those two classes and the numbers they're dealing with, right?
Mhm.
That's how much money they're bringing in. Well, the overall argument is that whatever percent of that stuff, well, let's get into the percentages. Right now in the UFC, fighters get anywhere from 10 to 17% of UFC revenue.
Yearly?
Yeah, or that's roughly what they're getting, right?
Mhm.
As a whole group of people.
Okay.
The NFL or any of the big four, right? Basketball, baseball, roughly
Mhm.
get 50% of the revenue of those institutions.
Mhm.
It's a huge difference,
That is.
right? So when we think about, again, start doing math, right? This is one way of start calculating some numbers. $500,000 or $500 million, they're only getting 10 to 17%. If they just matched, right? The NFL 50%, they should be getting 250 million of that, right?
Mhm.
Roughly spread out amongst the fighters.
Yeah.
That could be one number, right? Throwing that out there. But really, the process of figuring out damages is a long one, and it's going to involve. We're going back to this discovery thing that we talked about earlier. You're going to look for memos internally at the UFC talking about fighters' worth, right? When I was involved in litigation like this, that's one of the things we look for. How did they value X? How did they value the thing that we're fighting about, right? So that's one thing, right? Because if there's a memo somewhere floating around, which there might be, there may not be, I don't know, saying all fighters are worth $1 billion, that's great, right? For for the plaintiffs, they're like, okay, look, you can start with that number. That's how much they've assessed the value of their own fighters. And it becomes really hard for them to say, well, they're worth less. We're like, well, you already said that this is how much they're worth. Then, so you gather documents like that. And then what you do is you give them to an expert, an economist or whatever, damages expert, usually an economist or an accountant, depends. And then you tell them, well, knowing all of these facts about how much the company values these fighters at, and looking at the market, looking at other professional sports, looking at maybe, let's be real, they're going to be looking at boxing and how much some of the best fighters there make. How much, if all of these restrictive modes of doing business that the UFC has done didn't exist, how much more would the fighters make? That process is going to involve a lot of expert reports, which is the main thing they're going to put out. It's going to involve expert depositions. And in the expert report is when that first number is going to come out, right? And those may or may not be made public. They may or may not be made public. But if and when it ever goes to trial, experts that day is going to be very important, because that's when you're really talking about, you could lose a case and not lose still much money. But if you lose a case, man, both sides are going to, if the case is going really bad for Zuffa, they're really going to be focusing on how much they can bring down the number that is set up by the plaintiffs. So, it's important to keep those numbers in mind. About $500 million. They're only making 10 to 17% of the fighter revenues. So we'll see. We'll see how much that ends up being and where they end up looking to. They already have mentioned guys like Manny Pacquiao and Floyd Mayweather and their huge, ridiculous salaries in the complaint. You can bet that that's going to make it into the damages figure or estimate. But the actual number, I mean, I can't tell you. God only knows what it's going to be. But you can bet that those numbers that they've already quoted in there between bout money versus ancillary revenue, that's going to be it's going to play a role.
And couldn't one of the arguments be that they're able to keep the fighters' pay so low because they're monopolizing the system? That if there was more competition, then pay would be higher.
That is the argument. That is the essential. That's the exact argument that they've got to make, right? That's what the whole case is really about, is making that argument. Figuring out how much more. Well, that's why they pay those economists their money, to really figure out how much you can bring about with that. So, let's talk about a little bit of legal strategy and some shortcomings, maybe mistakes that were made in the complaint. So when you read this thing, one of the things you start realizing a bunch of is that they use a lot of quotes from Dana White. Dana White is in here quoted as calling the UFC the ultimate cash machine. They said that they're like the NFL. They are all about world fucking domination. All they use is quotes from interviews all the time. And why do they do this? Right? Why are they doing this? And this is, again, legal strategy. Put your hat, your lawyer hat on. Well, in part, they're doing it because for the journalists, for the jury eventually down the line, for the average folks, like those, they're trying to prove the monopoly through Dana White's words in the public. From a legal standpoint, whether those things are going to hold up or not, that's going to get argued quite a bit, excuse me. And it's a lot of those things might get stricken from the complaint for a variety of legal reasons I'm not going to go into. But it's hard, you're not going to prove your case through public statements like that, because at the end of the day, it could be just boasting. You know what I mean? Boasting that they're as big as the NFL. Well, anybody can say that, right? That doesn't mean you are that, right? So that, it's one of the things I noticed. They rely quite heavily on that. Fine, not a bad thing. I think it brings some color, but something to note. They're trying to prove their case like that, and when it comes down to it, they better have a lot more than Dana White's public interviews, because that's not going to be anywhere near enough. Then I think the big glaring omission is Bellator. Bellator, the other main, nowadays anyway, MMA promotional company out there, had one of the best middleweights in the world for a long time until he left them. Ben Askren is, they're up and running, man. They do pay-per-view fights, and they've attracted some people, and they've been able to have some prime time. They've even did a free televised event rather recently where they got over 2 million viewers. Obviously they were free, so they didn't have to pay anything. So it's always easier to get free people, free fights to get watched than paid ones. But they've got some eyes on them. Bellator appears very little in this complaint. So one of the biggest competitors or other promotional entities out there doesn't get mentioned. The UFC is going to be all over this. If there's no competition, how do you explain Bellator? How do you explain that the UFC has been in quite public price bids or bids against, for certain talent against Bellator? That's a question. It's a big question. It's a glaring omission. And again, legally speaking, you don't need to talk about that at this point. It's not required, but from for the journalists and the fans out there interested in this, they've got to be asking themselves, well, what's up with that? Like, why didn't they mention this, and what's going on there? Well, I'm going to tell you this much from a legal standpoint too. Eventually, they've got to have a damn good argument for it, and they do. And they kind of mentioned a little bit of things in there, but the fact of the matter is, they didn't address it enough, and they're going to have to come up with good explanations. And the one hint that they gave on the press conference call is they said, they directly denied giving an answer about Bellator, but in another part they said, sometimes in a monopoly there can still be actions that appear like competition.
Of course. So
one act of competition does not mean that a monopoly doesn't exist.
Of course. Right.
So, that's they might rely on that, but I think they're going to have something a little bit more meaty than that in and of itself. But that was definitely an omission from the complaint. And I think the last thing I'm gonna say sort of about the complaint is that the litigation itself is gonna give fans like you, fans like me, a peek behind the curtain, right? No matter what happens in the litigation ultimately, whether plaintiffs win, whether they lose, whether this thing lasts 10 years, as some antitrust litigation has lasted, throughout the process, especially if it gets to discovery and more of that stuff, we're going to get glimpses into a private company that we don't get otherwise, because the UFC is not a publicly traded company. They don't have to disclose documents to anyone. But in this litigation, they're going to have to disclose documents that they would never otherwise give out.
Exactly.
Right? And so we're going to get peeks into that. And this is the thing, how a company defends itself, how they address some of these arguments, they're going to get publicized. And so the company is not just in a position of defending itself legally against arguments, but it has to realize that these arguments are going to get out into the public, and how they're perceived by the public, even if they're good legal arguments, might hurt it. You know what I'm saying? And so we're going to get a sense of what the company really is and what it actually thinks of itself.
Yeah. How does it deal with the situation in the public eye?
Exactly. It's going to be an eye-opening experience, I feel like, for a lot of MMA fans out there.
Well, if they require their fighters to go out and promote them and defend them, you know, according to their contracts, then I think they'll be fine. They'll be okay.
I'm not sure it's gonna. I would say this much: you're probably gonna see the most hesitation from the fighters. They'll be like outright, like, "I'm not talking about that," or like, well, I'm not sure. They're gonna avoid this topic like the plague, because they want to keep their jobs. They want to keep their jobs. You know what I mean? They don't want to talk about this stuff. But I think that's going to do it for us here at Fight Like Sugar. If you have questions about the lawsuit, write them in the comments. Leave, tell us what you think about the lawsuit in general. Does the UFC have a monopoly in your point? If it does, do you care? I don't know. Maybe you don't. Maybe you're getting all the fights you want anyway. So leave some comments, and Fight Like Sugar on Twitter also, and subscribe. All right, until next time, keep those hands up.
This should be played at high volume.